My name is Kathleen and I'm the Executive Director for the Northern District Historical Society. A warm welcome to all of you joining us this evening in person and via Zoom. Thanks to our co-sponsors and to all of our members for making this event possible. We are also grateful to the operations staff here at the court. A few reminders: if you registered for CLE credit and are here in person, please be sure to sign the CLE attendance sheet before you leave this evening. For virtual attendees, we will know your attendance online. And if you have not already done so, please silence your cell phones. It's now my honor to hand things over to Northern District Historical Society Board Member Judge Rita, who will start our program off.
Good evening, everyone. Welcome to the United States District Court for the Northern District of California. We are gathered here to reenact one of the most consequential civil rights cases in American history, United States versus Wong, decided 128 years ago by the U.S. Supreme Court. That ruling guaranteed citizenship to those born on American soil, regardless of their parents' race or citizenship. As you will hear, it was handed down in a time of virulent anti-Chinese racism, a time when exclusion laws tried to strip an entire community of belonging in this country. What makes tonight especially meaningful is that this is where the case began. Wong was a San Franciscan detained at our court, and he filed his case in this court. We are the court and the community where this history was made. We are deeply honored to have Wong great grandchildren, Norman and Sandra Wong, join us with their families tonight, and have Norman and Sandra play themselves in this reenactment. Their presence reminds us of the courage it takes to be a plaintiff in a civil rights case, and the power of the communities that stand behind them. These lessons are as relevant today as ever. As many of you know, the question of who is entitled to birthright citizenship is once again before the United States Supreme Court. Thank you to our extraordinary cast, our 5 sitting judges, our lawyers, and our high school students from Lowell and Rita School of the Arts. These students have competed at the highest level of mock trial, and tonight they bring their talents to a case that is rooted in the history of their city. Thank you to Kathleen and to Alex Murray, who organized this entire evening. But most of all, we are grateful to the Asian American Bar Association of New York, who spent hundreds of hours on the archival research to develop this script. They made a special exception to allow us to use it in advance of their own reenactment in New York on May 27th. Please look for it and spread the word. We've made a few updates for tonight. Any errors are ours, but out of respect for Ava New York and their debut, we ask that there be no recording by the audience members tonight. Following the reenactment, we will hear from our panel, legal historian and professor Ming-Chi Chen, community historian David Lee, and law professor Amanda Tyler. They have graciously agreed to stay afterward to answer questions, so please seek them out at the reception. Let's begin.
On January 20th, 2025, within hours after being sworn in as president for the second time, Donald Trump signed dozens of executive orders, including Executive Order 14160, entitled Protecting the Meaning and Value of American Citizenship. He thereby ordered the government to stop treating as U.S. citizens the U.S.-born children of parents who are undocumented or in the country temporarily.
The following day, 18 states filed suit challenging Trump's order. California Attorney General Rob Bonta, first Filipino American to hold office, at this day.
The president's executive order attempting to rescind birthright citizenship is blatantly unconstitutional and quite frankly un-American. As home to Wong in San Francisco native fought successfully to have his U.S. citizenship recognized. California condemns President Trump to erase history and ignore 1 minute 25 years.
As this lawsuit and others challenging the executive order work their way through the courts, it has become important to revisit Wong Kim R versus United States, the 1898 Supreme Court precedent that established birthright citizenship for generations of Americans. In our program this evening, part of a series of historical reenactments developed by the Asian American Bar Association of New York, we will tell the story of Wong Kim R and his family and their fight for citizenship.
By 1870, there were 63,000 Chinese in the United States, drawn originally by the gold rush and the availability of work in the United States, and propelled by the difficulties of rural life in China. Over 3/4 of the Chinese lived in California. The arrival of nearly 139,000 more Chinese between 1870 and 1980, coupled with an economic recession in the 1870s, gave rise to a virulent anti-Chinese movement centered in California.
Shocking incidents of violence occurred as politicians and labor leaders proclaimed that the Chinese must go. In October 1871, a mob murdered 18 Chinese men in Los Angeles' Chinatown, including a 15-year-old boy, and on July 24, 1877, a mob attacked San Francisco's Chinatown, leaving 4 Chinese men dead.
The anti-Chinese efforts of California politicians went nationwide in the 1870s. In July 1876, the U.S. Congress sent a joint commission to San Francisco to investigate Chinese immigration. On October 18, 1876, the members convened for the first time and ultimately heard from 103rd witnesses. Frank Pixley, former California State Attorney General, was one of the first to testify about Chinese.
In regard to your second interrogatory, what is their moral and physical condition? They are immoral to the very last degree. They are atheists and heathens. Prostitution is a legitimized and accepted profession in China. It is as honored as the very lowest and menial professions, and it outranks that of the actor and is second only to that of the lawyer. As for their physical condition, the police can give you examples of the fearsome, loathsome, and terrible diseases that have affected civilization, which of itself is a sufficient menace to justify you in excluding a race from this continent that could transmit those diseases to those with American or Saxon blood.
The report concluded as follows.
The Chinese on the Pacific coast show few of the characteristics of a desirable population, and many to be deprecated by any patriot. This problem is too important to be treated with indifference. It must be solved, unless our Pacific possessions are to be ultimately given over to a race alien in all its tendencies, which will make of them practically provinces of China rather than states of the Union. The committee recommended that Congress legislate to restrain the great influx of Asiatics to this country. A duty is owing to the Pacific states and territories which are suffering under a terrible scourge, but are patiently waiting for relief from Congress.
Congress responded with the Chinese Exclusion Act in 1882, restricting an immigrant group explicitly on the basis of race for the first time in its history. The act barred Chinese skilled and unskilled laborers and Chinese employees in mining from entry and prevented Chinese immigrants from becoming U.S. citizens. Other exclusionary laws followed.
This was the America where Wong Kim R was born in 1870 on the second floor of 751 Sacramento Street, above the store his father owned with his partners in San Francisco's Chinatown. His parents had immigrated from the Guangdong province in southeastern China many years before he was born. His mother was one of fewer than 5,000 Chinese women in the United States, and he was one of only 518 ethnic Chinese born in the United States in 1870.
Soon after the violence in San Francisco's Chinatown in 1877, the Wong family, which by then included 8-year-old Wong Kim Ark and a younger brother, sailed for China. His parents chose never to return to America, but Wong Kim Ark did repeatedly, first with an uncle, most likely around 1881 when he was still a child. Upon his return to the U.S., he found work in a mining camp in the Sierra as a dishwasher and then as a cook before heading back to China again in 1889.
By then, he was 19, and he went back to be married and to conceive his first child. His new wife, Li Shi, was 16 and had the bound feet typical of women of merchant class. She remained in China when Wong sailed back to the United States on July 26, 1890. There he worked again as a cook, sending back whatever earnings he could to his family in China. In December 1894, he returned to China to meet his firstborn son and conceive a second child.
After the passage of the Chinese exclusion laws, travel between the U.S. and China became more difficult for Chinese Americans. For his trips back to China in 1890 and 1895, Wong was careful to comply with increasingly onerous paperwork that had already begun to characterize the immigration bureaucracy that developed in the wake of the Exclusion Act. In 1890, he carried his native-born affidavit with supporting statements from a white lawyer and a Chinese merchant. These proved adequate, and Wong was permitted to re-enter the United States, despite the notation in the file questioning his claims. Wong was not so fortunate in 1895, even though he was again careful to procure the required paperwork, this time supporting his native-born affidavit with statements from 3 white witnesses.
We do hereby certify that the said Wong Kim Ark is well known to us.
He was born in the city and county of San Francisco, state of California.
His father, Wong Si-ping, was a merchant and a member of the firm Wong Sing and Company, number 751 Sacramento Street, in said city and county of San Francisco.
By 1895, the federal courts had begun to grapple with the citizenship status of the Chinese born in America. Luk Ting Sing was born in Mendocino County in 1870. His father, a merchant, sent him to China in 1879 to be educated, doubtless because schooling was not available in California. When the boy attempted to return in 1884, he was denied entry on the basis of the Chinese Exclusion Act.
The boy and his family fought back, turning to the federal courts, as many Chinese have done since the passage of the Exclusion Act. Supported by local benevolent associations such as the 6 companies, Chinese litigants are estimated to have filed at least 7,000 lawsuits in the first 10 years of the Act. Luk Tim Sing was represented by 2 prominent white attorneys, Thomas Reardon and a former Attorney General of California, William Stewart. Luk prevailed in an 1884 panel ruling authored by Associate Justice Stephen Field, U.S. Supreme Court, Ryan Circuit.
The 14th Amendment to the Constitution declares that all persons born or naturalized in the United States who are subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. This language would seem to be sufficiently broad to cover the case of the petitioner. He is a person born in the United States, and no citizen can be excluded from this country except for punishment for crime. Exclusion for any other cause is unknown to our laws and beyond the power of Congress. The petitioner must be allowed to land. It is so ordered.
The Luk Tin Sing ruling proved to be an important precedent, with lower federal courts following the rule that anyone born in the United States was a citizen. However, some Americans were adamant that Luk Tin Sing was wrongly decided and lobbied for a test case to finally determine the question. San Francisco attorney George Collins wrote frequently about birthright citizenship, which resulted in a newspaper spat with Justice Field.
The Luk Tin Sing ruling is very poor law. The evil effects of Justice Field's decision
have now become so virulent and diffusive that the necessity of a ruling by the Supreme Court defining what constitutes a native-born citizen has become one of pressing urgency.
Mr. Cowell's views are entirely without merit. The publication primarily serves the vanity of the writer by seeing crudities and growth.
Justice Field's insults do not surprise me. His supreme veneration for his own opinion is a matter of common knowledge, and of course, he brooks no dissent from his views.
In seeking their test case to bring before the Supreme Court, the government selected Wong Arps. Upon his return from China in August 1895 aboard the Coptic, San Francisco Collector of Customs John Wise directed the speech company to keep Wong on board. When the Coptic left, he was transferred to the Gateway, and when it departed, to the Peking. Despite the enormous number of habeas petitions being filed in those days, the newspapers reported in October on this in a news item that was circulated nationwide.
Question of citizenship for the Chinese is to be decided in the courts. The citizenship of Wong Kim Ark has been denied at the San Francisco Collector of Commons, as according to an agreement with the Attorney General of California, who is eager to ensure that California, who is eager to test the right of native-born Chinese to land.
On October 1st, 1895, San Francisco attorney Joseph Napoli filed a petition for a writ of habeas corpus on behalf of Wong's friend, Wong Soy. The next day, Judge William Morrow of the Northern District of California ordered the master of the Peking to produce Wong in court, and Wong was thereafter committed to the custody of the U.S. Marshal. A second and more complete petition was filed on November 11th, this time with the assistance of Thomas Reardon, one of the attorneys on the same case, and the matter came on for hearing that same day. An agreed statement of facts was filed, and the matter was argued by the U.S. Attorney for the Northern District of California. Henry Foote, Reardon, and Napoli, and the written schedule was set.
George Collins had urged Solicitor General Holmes Conrad to appoint him special counsel, but Foote advised against it, referring to Collins's bad reputation as regards professional ethics. Indeed, Collins was later charged with bigamy and perjury, convicted of the latter, and sentenced to 14 years in prison. Collins submitted an amicus brief instead. It is unclear whether any oral argument was actually held in the district court, but newspaper coverage of the positions taken suggests an exchange along these lines.
Wong Kim Ark was born in this country and is therefore a citizen of these United States. This petition is brought to have the broad principle of citizenship settled for all time. Think of all the people in this country who have been born of parents who owed allegiance to Great Britain, Germany, Italy, or some other European power. Are all of these people to be declared not citizens?
This is an entirely different situation. The children born to immigrant Caucasian parents enjoyed a possibility of becoming citizens, which is denied to the Mongolians, who are not free white persons eligible to be naturalized under the law. Wong's minimal education and political affiliation as a subject of the Emperor of China disqualifies him. He, and indeed all of the olive-skinned Orientals, cannot claim citizenship by mere accident of birth.
In his brief, Collins pressed the point that the child of alien parents is not subject to the jurisdiction of the United States, but rather subject to foreign powers.
This old English common law of birthright citizenship, based upon the soil on which one is born, is anti-republican, anti-national, anti-American, and antagonistic to the principles of the revolution. Only a law based upon dissent can protect the nation against the ragtag and bobtail of humanity who happen to be deposited on our soil by the accident of birth, and whose education and political affiliation are entirely alien.
By November 19th, the matter was fully submitted. Judge Morrow issued his decision on January 3rd, 1896.
arriving at the conclusion that the Supreme Court has as yet announced no doctrine variance with that contained in the same decision, I am constrained to follow the authority, law enunciated in this circuit. Counsel for the United States have argued with considerable force against the common law rule being illogical and likely to lead to perplexing and perhaps serious international conflicts if followed in all cases. But these observations are obviously addressed to the policy of the rule, if not to its interpretation. The doctrine of the law of nations, that the child follows the nationality of the parents, and that citizenship does not depend upon mere accidental place of birth, is undoubtedly more logical, reasonable, and satisfactory. But such consideration will not justify this court in declaring it to be the law against controlling judicial authority. From the law as announced and the facts as stipulated, I am of the opinion that Wong Kim are a citizen of the United States within the meaning of the Citizenship Clause of the 14th Amendment. He does not forfeit his right to return to this country. His detention, therefore, is illegal. He should be discharged, and he is so.
Wood promptly moved to appeal directly to the Supreme Court, and happily moved with Wood's consent to have Wong released from custody pending appeal on payment of a bond of $250. While reorganization of the federal courts in 1891 had created an intermediate level of appeal in the circuit courts, an exception existed for issues involving the Constitution. Both motions were granted, and after being imprisoned on ships for 125 days, Wong was finally permitted to walk onto dry land in San Francisco upon payment of what would be close to $10,000 to pay.
As Wong's case moved to the Supreme Court, nationwide issues that had been simmering since the Civil War came into play. The habeas corpus act that enabled Wong to bring his case in federal court had been passed in 1867, in part to protect Union sympathizers and freedmen whose rights were threatened in the South. Issues of federal protection for citizens' rights and questions of state sovereignty and racial equality were all involved.
U.S. Attorney Foote and Solicitor General Holmes Conrad had both served in the Confederate Army. For Conrad, Wong Kim Ark was an opportunity for attacks on the 14th Amendment and Reconstruction before the highest court in the land. He was lead counsel for the government, supported by George Collins. Maxwell Evarts and Hubly Ashton, hired by the 6 companies to represent Wong, were Supreme Court veterans. Thomas Reardon filed a short brief as well. Although originally set for the October term 1895, apparently all counsel, but especially the government, thought it best to avoid the politics of the 1896 presidential election.
The case was argued in the Supreme Court over the course of 2 days, beginning on Friday, March 5th, 1897, the day after Chief Justice Melville Fuller swore in William McKinley as the 25th President of the United States. The court heard the case in the old Senate chamber at the U.S. Capitol, with Chief Justice Fuller presiding. No transcript exists of the argument, but we have summarized and reconstructed the argument based on the briefs and the court's opinion.
We'll hear from the government. General Conrad.
Madam Chief Justice, the clerks, Wong Kim Ark is not a citizen of the United States. He may have been born in this country, but his parents were not. Indeed, they were subjects of the Emperor of China. We acknowledge that it is generally thought to be the law that a person born within the United States is a citizen hereof, irrespective of the nationality of his parents. But that rule has never been justified and is not sustainable by any principle of international or constitutional law. It has its origin in the English common law, that birth within the allegiance of the king made that person a subject of the king, even though he was born of alien parents. But we do not live in a monarchy in this country. Instead, we have a republican form of government. The true bond that connects the child to the body politic is not the matter of an inanimate piece of land, but the moral relations of the parents. Nor does the 14th Amendment, even assuming that it was lawfully adopted, suggest otherwise.
The parents of Wong Kim Ark who were physically present here in this country, weren't they therefore subject to the jurisdiction of the United States?
In some sense, Justice Field, perhaps. Aliens temporarily in this country are, to a certain extent, subject to its jurisdiction. They must obey the laws, keep the peace, pay their debts, but there are limits. They cannot be placed upon juries or made to work the public roads or to bear many of the burdens that rest upon those who are subject to the complete jurisdiction of the United States. In fact, of course, the Chinese are prohibited from naturalization.
But the words are clear, are they not? Subject to the jurisdiction of the United States. Should we not give those words their plain meaning?
Respectfully, Justice Gray, the words subject to the jurisdiction thereof apply only to those who are subject to the complete jurisdiction of the United States. The words were not intended to extend to the children of Chinese parents who were the subjects of a foreign power, who resided here only temporarily and for purposes of business, who left China not with the intent to stay and settle in this country, but to return to what they clearly considered their homeland.
As a matter of public policy, does it make any sense to deem a child born here an American citizen merely because his alien parents, subject to the jurisdiction of a foreign power, happened to be present when the child was born?
It does not make sense, Your Honor. When Wong Kim Ark was born, his parents were subject to the jurisdiction of the Chinese emperor. They could not have been subject to the same extent to the jurisdiction of the United States, for no man in a political domain can serve two masters. The domicile of the parent is the domicile of the child. Their people are his people. Wherever the parents go, the child goes. If the decision below is affirmed, the anomalous result would be that a Chinese infant born in this country could be torn from the breast of his mother, who under our laws could be banished from our shores as an alien and foreigner while her child remains.
Although it does not appear that you participated in the oral argument, Wong submitted a separate brief in which he attacked the Chinese, arguing as follows.
For the most persuasive reasons, we have refused citizenship to Chinese subjects. And yet, as to their offspring, who are just as obnoxious, and to whom the same reason for exclusion applies with equal force, we are told that we must accept them as fellow citizens, all because of the mere accident of birth. There certainly should be some honor and dignity in American citizenship that would be sacred from the foul and corrupting taint of a debasing alienage. Are Chinese children born in this country to share with the descendants of the patriots of the American Revolution the exalted qualification of being eligible to the presidency of the nation, conferred by the Constitution in recognition of the importance and dignity of citizenship by birth? If so, then verily there has been a most degenerate departure from the patriotic ideals of our forefathers. And surely in that case, American citizenship is not worth having.
Evans and Ashton submitted separate briefs, and it appears that they both argued. Here is Maxwell Evers.
Mr. Everts, you may proceed.
Mr. Chief Justice, may it please the court. Whether Wong Kim Ark shall be permitted to land, and what the rights of the Chinese may be are of little importance. This case is much larger and broader. For if the government's position is accepted, what will be the impacts on the children of the English, Irish, French, German, or any other extraction?
Wong's parents were subjects of the Emperor of China when he was born, were they not?
Perhaps, Your Honor, in some limited sense. But when Wong Kim Ark was born, his parents were surely subject to the jurisdiction of the United States, within any plain construction of the words. Under the authorities cited in our brief, his parents could have been tried for treason, and his father could have been drafted into the armies of the United States to defend against a foreign invasion. If the government's position is accepted, then we would have independent Chinese, English, and German kingdoms within our boundaries, and their children born in these communities would remain Chinese, English, and German subjects.
As a matter of international law, aren't there many countries that follow the rule of jus sanguinis, that is, following the blood?
The people of this country intended that the words in the 14th Amendment would be interpreted not in accordance with Roman law or the law of France or some other country, but in accordance with the law of the United States, including as set forth in the case of Luk Tin Singh. There, Justice Field recognized that when Luk Tin Singh was born in this country, he was subject exclusively to the jurisdiction of the United States and not to the jurisdiction of any other country.
Ashton focused on the 14th Amendment.
The 14th Amendment sought to cast aside prejudice based on race and pretension based on caste. It provides unequivocally that all persons born in the United States and subject to the jurisdiction thereof are citizens of the United States. The language cannot, by construction or interpretation, be confined to persons of the Caucasian race and persons of African descent, to the exclusion of persons of Mongolian descent.
What do you make of the government's suggestion that the 14th Amendment was not validly adopted?
That is nonsense, Your Honor. The 14th Amendment is a valid part of the Constitution, and its plain meaning is that all persons born upon the soil and subject to the authority and laws of the United States, irrespective of nationality or color or race or prior political condition of their parents, are citizens of the United States. The government's newfangled theory of the law of descent would create a new race of aliens, all born in the United States, but without citizenship, doomed by the Constitution to perpetual alienage in the country of their birth, their homes, and their affections.
The court did not issue an opinion for over a year. On March 28, 1898, the court finally ruled. Only 8 justices participated in the ruling, as Justice Stephen Field, who was on the court when the case was argued, retired in December 1897, and his replacement, Justice Joseph McKenna, did not join the court until after the case was argued. Justice Horace Gray wrote for the 6-2 majority.
The 14th Amendment affirms the ancient and fundamental rule of citizenship by birth within the territory, in the allegiance and under the protection of the country, including all children born of resident aliens, with the exceptions of children of foreign sovereigns or their ministers, or born on foreign public ships, or of enemies within and during a hostile occupation, and with the single additional exception of children of members of the Indian tribes owing direct allegiance to their several tribes. The amendment, in clear words and manifest intent, includes the children born within the territory of the United States and of all other persons of whatever race or color domiciled within the United States. Every citizen or subject of another country, while domiciled here, is within the allegiance and protection and consequently subject to the jurisdiction of the United States.
The court made plain one of its principal concerns, the impact on children of European descent.
To hold that the 14th Amendment of the Constitution excludes from citizenship the children born in the United States of citizens of other countries would be to deny citizenship to thousands of persons of English, Scotch, Irish, German, or other European parentage who have always been considered and treated as citizens of the United States.
The court addressed the government's argument that the Chinese Exclusion Act reflected the belief that the Chinese were not worthy of citizenship.
Whatever considerations might influence the legislative or executive branch of the government to decline to admit persons of the Chinese race to the status of citizens of the United States, there are none that can constrain or permit the judiciary to refuse to give full effect to the peremptory and explicit language of the 14th Amendment. Chinese persons born out of the United States, remaining subjects of the Emperor of China, and not having become citizens of the United States, are entitled to the protection of and owe allegiance to the United States, so long as they are permitted by the United States to reside here, and are subject to the jurisdiction thereof in the same sense as all other aliens residing in the United States.
Chief Justice Fuller, joined by Justice Harlan, dissented.
I cannot concur in the judgment and opinion of the court in this case. The children of aliens whose parents have not only renounced their allegiance to their native country, but are forbidden by its system of government, as well as by its positive laws from doing so, and are not permitted to acquire another citizenship by the laws of the country into which they come, must necessarily remain themselves subject to the same sovereignty as their parents, and cannot, in the nature of things, be, any more than their parents, completely subject to the jurisdiction of another country. Tested by this rule, Wong Kim Ark never became, and it is not a citizen of the United States, and the order of the district court should be reversed.
That Justice Harlan joined the dissent may have been surprising to some, as he had been the lone dissenter in the court's 1896 decision in Plessy versus Ferguson, which established the separate but equal doctrine. He argued there that our Constitution is colorblind. However, his dissent in Plessy also contained the following lines.
There is a race so different from ours that we do not permit those belonging to it to become citizens of the United States. Persons belonging to it are, with few exceptions, absolutely excluded from our country. I allude to the Chinese race.
Newspaper coverage of the decision in Wong Kim Ark was not extensive, in all likelihood because the nation was focused on imminent declaration of war on Spain, and in practice, it did not resolve the difficulties experienced by the citizens of Chinese ancestry in their interactions with the government. The Secretary of the Treasury, whose agency at the end of the 19th century was in charge of immigration enforcement, endorses the view taken by his officials.
The Chinese are an undesirable addition to our society. Every presumption, every technicality, every intendment should be taken against their admission, and their testimony should be given little or no weight, especially when it stands alone.
Wong did not return to China for many years. Any hesitation he had was likely reinforced by his experience with immigration authorities in El Paso, Texas in 1901. On October 29th, Wong was arrested after he crossed into the United States from Juarez, Mexico. At the time, the economies of Juarez and El Paso both relied on Chinese labor and merchants. The 1900 census listed 336 people of Chinese descent among El Paso's population of nearly 25,000, almost all men working in laundries and restaurants.
Wong was freed on a $300 bond guaranteed by Mar Chu, who was listed as a restaurant owner in an El Paso directory, and R.F. Campbell, a former mayor.
The records do not indicate how they knew Wong or each other. The case against Wong was finally dismissed on February 18, 1902 by W.D. Howe, then serving as United States Commissioner for the Western District.
The United States of America set an open court. It would no further prosecute this cause and asked that the same be dismissed. For the reason that the officers charged with the enforcement of the Chinese Exclusion Act believe that this defendant, Wong Kim Ark, is the same Wong Kim Ark who was decided by the Supreme Court of the United States on March 28, 1898, to be a citizen of the United States of America. It is the order of the court that said defendant, Wong Kim Ark, be and he is hereby discharged, and that he go hence without delay.
We do not know how long Wong stayed in El Paso. A 1903 city directory lists a person by that name, identified as a cook, as the resident of a boarding house located on South Oregon Street, which was then part of El Paso's small Chinatown. Today, that street is home to Mexican restaurants and stores.
Wong did not return to China until 1904, some 6 years after his victory at the Supreme Court. Photograph attached to his departure affidavit shows a man who scholars have described as looking confident, even happy. He saw his wife and children in Hong Sing village. Wong came back to the United States in 1905 and returned to China again in 1913. He finally went back to China for the last time in 1931 at the age of 61. That year, Wong filed an application in which he stated that he planned to come back to the United States, but he never did. We do not know when or where he died.
For Wong, the Supreme Court decision meant more than the right to travel between America and China. The nation's very first citizenship statute, the Naturalization Act of 1790, established that children of U.S. citizen fathers born abroad claim citizenship as long as their fathers have resided at some point in the United States.
Wong not only understood this law, but actively relied upon it. He claimed to have 4 sons, each of whom sought entry into the United States as the child of a native-born citizen, thereby asserting their U.S. citizenship. Like their father, Wong's sons were met with suspicion upon their arrival at the port of San Francisco. On each occasion, Wong gave the sons sworn affidavits affirming that they were indeed his sons, and either provided sworn written testimony or appeared in person to support their entry upon arrival.
The first of his claimed sons to enter was Wong Yo-Fun, who arrived on the SS Korea in the port of San Francisco on October 28, 1910, more than a decade after the Supreme Court decided his father's case. He brought with him a notarized affidavit signed by Wong Kim Ark on January 31st, 1910, which he presented upon landing. In his affidavit, Wong Kim Ark used the Chinese Feng Shui or KS calendar. For purposes of this reenactment, we have retained the references to KS dates in the affidavits and hearing transcripts, but we provide the corresponding Gregorian calendar dates in the slides accompanying the presentation.
I hereby make affidavit that my name is Wong Kim Ark. I am a citizen of the United States by birth, which was decided by the Supreme Court of the United States on March 28, 1898. A copy of the judgment issued at that time is hereto attached. On KO 15th, 11th month, 12th day, I was married to one Yi Shi in the village of Tongsing Li, Canton, China. In KO 16th, 9th month, 7th day, there was a male child born to myself and wife in said village, whose picture is attached. The name of this boy is Wong Yo-Fun. He is my lawful son, and I desire to have him come to the United States to be educated for whatever occupation or calling he may see fit as best for him. I claim his admission to the United States on the ground of his being a son of a citizen of the United States.
Immigration officers, however, refused entry and detained Wong Yo-Fun on Angel Island. Inspector Heitman interviewed him on December 2nd, 1910, nearly 2 months after he arrived. The interview, which was transcribed, reveals the kind of questioning that immigration officers directed to Chinese immigrants on Angel Island. Wong Yo-Fun had not seen his father in over 5 years.
What are your names?
Wong Yo-Fun.
You married?
No, never been married.
Do you have any children?
No.
And how old are you?
21.
How long did you go to school?
So I was 18 years old.
And what did you do?
In business with Wen Simco Ik Toy Market.
What is your father's name?
Wong Kim Ark.
How old is he?
40, I believe he's 40.
When did you see him last in China?
End of KS 31.
And when did he return to the US?
KS 31, end of that year.
And how long was he in China at that time?
About a year.
And what does he do in the US?
He's a cook in El Paso, Texas.
Inspector Heitman proceeded to ask many other questions, including how much money his father had sent his family through a US acquaintance who returned to China. The inspector also asked about the names of the people residing in the village, the location of the houses, and the names of the people living in the houses.
How large is your village in China?
35 houses,
How many rows of houses?
7 rows, but only 6 of them have houses on them.
And where is your house?
From the north, first alley, 3rd house,
Which way does your village face?
east,
And how many houses are on the first row?
4.
After asking more questions about the number of houses per row, Inspector Heitman commented,
That is only 29 houses. You said there were 35. Where are the other houses?
Well, there are 35 lots, but only 29 houses have been built.
Who lives in the first house?
Wong Kim Fong does.
Is he married?
No, he's not.
Does he live there?
His mother, his wife is dead.
After completing the examination, Inspector Heitman submitted a report dated December 2nd, 1910 to the Chief Chinese Inspector on Angel Island.
I'm taking the statement of the applicant. The alleged father and witness are in El Paso, but this case should be further investigated. I would suggest that the alleged father be asked questions along the lines of my examination, particular attention being paid to the occupants of the houses in the home village, concerning which minute details should be obtained. The alleged father should be required to draw a diagram of his home village similar to the one enclosed.
A few days later, on December 6th, 1910, Wong Yo-Klan wrote to his father. His letter was translated into English by an interpreter and addressed to Wong Kim Law, care of Wong San Lung Company, 8 Oregon Street, El Paso, Texas.
Dear Father, I am in a detention shed. I am well. Please do not worry about me and buy me some clothes. 6 socks and a cap. Also some money. Your son, Yu-Fu.
That same day in El Paso, Texas, Wong Kim Ark provided sworn testimony to support his son's entry as a U.S. citizen. Examination officer Louis Robinson questioned him for 2 days, and the exchange was transcribed.
What is your name?
Wong Kim Ark.
What is your marriage or courtesy name?
Wong Do Fong.
Do you have any other names?
I have the American name of Jim.
How old are you?
40 years old.
Where were you born?
I was born at 751 Sacramento Street, San Francisco, California.
What evidence have you, if any, of your birth in San Francisco?
Wong proceeded to show several documents, including copies of his certificate of identity, which bore his photograph, and of the judgment issued in Texas dismissing the charges against him for being unlawfully in the United States. The examination continued.
For whom do you appear a witness?
My son, Wong Yo-Fun.
Where is he now?
He is at San Francisco now.
How old is he?
He's 20 years old, but according to the Chinese calendar, he would be 21. He was born in KO 16 in the 9th month, 7th day.
Is he married?
No, sir.
Where was he born?
At Ong Sing Village.
Officer Robinson proceeded to ask many other questions, including questions about when Wong's mother died, how many children he has, how much money he sent through the acquaintance in the U.S. who returned to China, and Wong Yo-Fun's occupation, which he described as nothing in particular of any kind. The officer also asked about the names of the people residing in the village, the location of the houses, and the names of the people living in the houses.
The interpreter under your direction has drawn a diagram of Ong Sing Village. Is that diagram correct?
That was the situation when I left there in KO 31. It was approximately situated this way, but all these occupants in these houses, I'm not sure of their names. I've given some of their names and some of them I cannot recall.
On December 18th, 1910, Inspector Hartman recommended denial of entry.
I have taken the statement of Wong Yong-kun, and I have now reviewed the statement of the alleged father. There are numerous discrepancies in the testimony. Applicant states that his paternal grandmother died before he was born. Alleged father states that she died in 1901 or 1902. But in 1901 or 1902, applicant was 11 or 12 years old, and as the grandmother died in the home village, she should really know this. The applicant and alleged father do not agree upon the location of any of the occupants in the village, of the house in the village. They agree on naming only one person living in the village. The above shows clearly the fraudulent nature of this case, therefore, I recommend denial.
Wong Yong-kun was deported on January 9, 1911 on the SS Mongolia. There is no record of him returning to the United States. More than 10 years passed before Wong Kim-ark's other sons sought to enter the United States. On July 11, 1924, Wong's third claimed son, Wong Yuk-soo, who was then 19 years old, arrived on the SS President Lincoln. On March 10, 1925, second son, Wong Yuk-tui, who was 31 years old, arrived at the port of San Francisco. On June 30th, 1926, the fourth son, Wong Jin-yuk, arrived. He was only 13 years old.
Much like their oldest brother, they were subjected to rigorous examination by immigration officials. All were questioned about their relationship to Wong and other family members, locations of houses in the village, and details about relatives. In each case, Wong Kim-ark provided sworn testimony to corroborate their identities and to affirm his parental connection to them. Ultimately, unlike their brother, all three were admitted to the United States and recognized as U.S. citizens.
But what of their mother, Yi Shi? Very little is known about her. She was 16 years old when Wong met and married her in 1889. In testimony during his son's immigration examinations, officials repeatedly asked Wong to describe her physical appearance, focusing in particular on whether she had bound feet, a question to which he consistently responded yes.
Had Yi Shi not been Chinese, she would have acquired U.S. citizenship through her marriage to Wong, and like her sons, she would have been eligible to reside in the United States. Since 1855, U.S. law provided that foreign-born women who married U.S. citizens automatically obtained their husband's citizenship. However, this law applied only to women who were otherwise eligible for naturalization. And because individuals of Chinese descent were barred from naturalization, Yi Shi was effectively barred from entering the United States. This is perhaps why Wong did not come back to the United States after his last trip to China in 1931, choosing to spend the last years of his life with a wife he had seen only rarely since the marriage.
The experience of the Wong family with the U.S. immigration bureaucracy was not unusual. Inspectors determined to root out fraud subjected the Chinese to days of hearings and weeks or months of detention. Historians report that birthright citizens returning from China did occasionally report to immigration officials falsely that they had fathered a son in China, subsequently providing paperwork to bolster the child's entry into the United States, the paper son.
The Wong family's desire to come to America was also not unusual. Many Chinese, legally barred from entry by discriminatory laws, resorted to buying paper to take advantage of provisions in the laws that would permit the children of U.S. citizens to enter. These paper sons were willing to risk everything to come to America and to eventually bring their families to join them, despite hostility and suspicion they knew they would face, to make better lives for themselves and their loved ones.
In the years after Wong Kim-ark versus United States, the Supreme Court repeatedly confirmed that all individuals born in this country, including children of undocumented non-citizens or natural-born citizens. Here is Justice John Marshall Harlan II in the Shaughnessy case in 1957, referring to a child born here of parents who had overstayed their authorization to be in this country.
The child is, of course, an American citizen by birth.
Here is Chief Justice Earl Warren in INS versus Errico in 1966, referring to a child born here to non-citizens who entered this country under false pretenses.
The child acquired United States citizenship at birth.
And finally, here is Justice Brennan for the court in Tyler versus Doe in 1982.
Texas argues that undocumented aliens, because of their immigration status, are not citizens within the jurisdiction of the state of Texas, and they therefore have no right to the equal protection of Texas law. We reject this argument. Whatever his status under the immigration law, an alien is surely a person in any ordinary sense of that term. Aliens, even aliens whose presence in this country is unlawful, have been recognized as persons guaranteed due process of the law by the 5th and 14th Amendments. Justice Gray concluded in Wong Kim Ark that every citizen or subject of another country while domiciled here is within the allegiance and the protection, and consequently subject to the jurisdiction of the United States. Given the historical emphasis on geographic territoriality, bounded only, if at all, by principles of sovereignty and allegiance, no plausible distinction with respect to the 14th Amendment jurisdiction can be drawn between resident aliens whose entry into the United States was lawful and resident aliens whose entry was unlawful.
Birthright citizenship has never ceased to be an issue for people born in certain U.S. territories, including Philippines, Guam, American Samoa, and Puerto Rico. The Insular cases, a series of decisions issued by the Supreme Court starting in 1901, limited the scope of constitutional protections for such individuals. Efforts to overturn the Insular cases, including a 2021 case in the 10th Circuit, have not been successful. But for individuals born in all states of the United States, birthright citizenship has remained the law of the land.
We return to the January 20th, 2025 executive order entitled Protecting the Meaning and Value of American Citizenship. The title calls to mind for some the Joint Committee's report in 1877 and George Collins's argument to the Supreme Court about the need to protect the honor and dignity of American citizenship from the corrupting taint of a debasing alienage. And indeed, the arguments swirling today in courtrooms, media, and academic circles all have their echoes in the briefs filed and arguments made more than 100 years ago.
The first lawsuit challenging President Trump's birthright citizenship order was filed within hours after the order was signed, as 3 civil rights and immigrant rights groups sued in New Hampshire. The next day, 3 more cases were brought, one by 5 pregnant women and others in Maryland, another by 18 states and the District of Columbia and the city and county of San Francisco, joining the case in Massachusetts, and the third by 4 more states in Seattle.
District judges quickly issued temporary restraining orders and nationwide preliminary injunctions enjoining implementation of the executive order. Here are Judge John Pooner in Seattle and Judge Deborah Borden in Maryland.
I have been on the bench for 4 decades. I can't remember another case with the question presented. It is clear this is a blatantly unconstitutional.
The executive order conflicts with the plain language of the 14th Amendment, contradicts 125-year-old binding Supreme Court precedent, and runs counter to our nation's 250-year history of citizenship by birth.
The administration sought stays of the nationwide injunctions in 3 circuit courts. The National Asian Pacific American Bar Association, NAPABA, and 43 of its affiliates joined a coalition of national, state, and local bar associations that filed an amicus brief in the 9th Circuit. All 3 circuit courts denied stays. The administration then made 3 emergency applications to the Supreme Court, seeking to partially stay the injunctions to limit relief to the parties in the lawsuits. On June 27, 2025, in a 6-3 decision, the court addressed the question of nationwide injunctions and ruled in favor of the administration. Here is Justice Barrett for the majority.
Traditionally, courts issued injunctions prohibiting executive officials from enforcing a challenged law or policy only against the plaintiffs in the lawsuit. The injunctions before us today reflect a more recent development. District courts asserting the power to prohibit the enforcement of a law or policy against anyone. These injunctions, known as universal injunctions, likely exceed equitable authority that Congress has granted to federal courts. We therefore grant the government's application to partially stay the injunctions entered below.
Justice Barrett was careful to say, however, that the court was not reaching the merits of lawfulness of the executive order.
The applications do not raise, and thus we do not address, question whether the executive order violates the Citizenship Clause or Nationality Act. Issue before us is one of remedy, whether under the Judiciary Act of 1789, federal courts have equitable authority to issue universal injunctions.
The court left open the possibility that challengers to the executive order could bring class actions to seek to bar enforcement of the executive order on a statewide or even national basis. The plaintiffs in the various cases filed new class action complaints. Stays of the executive order have thus remained in place as the litigation continues.
The Department of Justice filed petitions for certiorari in 2 of the cases on September 26, 2025. The government argued
The Citizenship Clause of the 14th Amendment is adopted to grant citizenship to newly freed slaves and their children, not to children of temporary visitors or illegal aliens. The plain text of the clause, its original understanding and history, and this court's cases confirm that the clause extends to children who are completely subject to the political jurisdiction of the United States, meaning that they owe direct and immediate allegiance to the nation and may claim its protection. Wong Kim Ark does not hold otherwise. Wong Kim Ark recognized that the Citizenship Clause guarantees U.S. citizenship, not just to children of U.S. citizens, but also to children of aliens enjoying a permanent domicile and residence in the United States. And the opinion suggests that U.S. citizenship does not extend to the children of aliens who are not permitted by the United States to reside here.
In responding briefs filed October 29, one group of plaintiffs did not oppose certiorari in hopes of a quick resolution on the merits, and noted as follows.
Wong Kim Ark authoritatively reviewed the history and original understanding of the Citizenship Clause and effectively rejected every argument petitioners have made.
On December 5th, 2025, the Supreme Court granted the Trump administration's petition for review in the Barbara case. The court decided to take up directly the question of whether the executive order violates the 14th Amendment by refusing to treat children born in the United States as citizens if their parents were undocumented or in the country temporarily. Oral argument took place on April 1st, 2026, and the decision was expected by late June or early July.
When City Attorney David Chu and other local officials announced that San Francisco would join the state's lawsuit against the Birthright Citizenship Order, they gathered at the Chinese Consolidated Benevolent Association on Stockton Street, current home of the association, formerly known as the Six Companies. Renewed interest in Wong Kim Ark's case has attracted historians, the media, legal scholars, community groups, and individuals whose lives have been impacted by the forces at work in that case, including many who have only recently started learning about it.
More has come to light about Wong Kim Ark's family. It appears that Wong Kim Ark's third claimed son, Wong Yuk-sui, was in fact a paper son and not actually related to Wong Kim Ark. Wong Yuk-sui became known as Ernest Wong, and in the 1960s, he came forward as part of the Immigration and Naturalization Service's Chinese Confession Program, designed to root out Chinese communists. Men like Ernest Wong were typically approved for permanent residence, absent leftist leanings.
Ernest Wong was careful to mention in his confession that he believed that Wong Kim Ark was born in the United States, and that Wong Jin-yuk, the youngest claimed son, was a true son of Wong Kim Ark. By then, Wong Jin-yuk, who became known as James, had been in the U.S. for 34 years, working first as a waiter in Chinese restaurants before serving in the U.S. Army during World War II, and then serving 25 years in the Merchant Marines. He married a Japanese-American woman and raised a family with her in San Francisco. After James read about the celebration of the 100th anniversary of Wong Kim Ark's case in 1998, He enlisted the aid of his granddaughter to learn more. Together, they attended the ceremony making Angel Island National Historical Landmark.
James died in 2011. Thereafter, his children dug deeper into the family history and learned that, in all likelihood, James was not Wong Kim Ark's son, but his grandson. Norman Wong is James's son, and he believes that Wong Kim Ark was not his grandfather, but his great-grandfather. Growing up, he did not know his father's story or the story of his Japanese-American mother, who had been sent to the Topaz internment camp with her family at age 15 during World War II. Last year, he spoke at a campus forum on immigration issues at the University of California at Berkeley and appeared with San Francisco officials as they unveiled a plaque honoring Wong Kim Ark and declared March 28, 2025, Wong Kim Ark Day. Sandra Wong is Norman's younger sister, and in 2016, she participated in a documentary about the fight for citizenship. In interviews, Norman and Sandra had this to say.
We grew up ignorant about both sides of my parents' history. As we learned more, we thought it was a dead issue. These were rights that we did not have to fight for anymore. It wasn't something that anybody would have to worry about, really. It was just a footnote in history. Now, I'm glad my great-grandfather stood up. Him doing that gave me something I never had before. A validation of my own life. And yes, I'm proud of him, but remember, he was a stranger to me. It's kind of like Wong Kim Ark is for all of us. He's not for me to own. Add one more point. I'm not an authority on my own family history. I depend on the work of others. However, for me, the quest to learn about my family is an ongoing process. When my beliefs differ from what has been previously written, I'm not doubting that work. Even others in my own family may disagree with me. I am only saying what I believe at the moment. As evidence changes, my beliefs may change. But I want to say to you what I honestly believe. You deserve that. Fractured as my family history is, the truth may never be fully revealed to me. Thank you.
What does this all mean? It comes down to something that was unjust. Sometimes Wong Kim Ark was called a hero, but I always thought that he was just doing what anyone would do. He stood up for his rights and for what he believed. Wouldn't anyone do that?
Thank you for that wonderful reenactment, and thank you to Norman and Sandra for being here with us. We're going to turn to a short panel to give our a little bit more context and perspective, and then we will turn to the reception after that. So we will begin with Rita, who is a community historian here in Chinatown. Then we'll turn to Amanda, who is a professor at UC Berkeley School of Law, and then I'll have short words. I think Sue Chan and I'm a professor at UC Los Angeles.
Thank you. I just want to give some context of what Chinatown was like during Wong Kim Ark's time. He wasn't the first case. There were several, and the Inri Lupton Singh case was the case that was used for the Supreme Court Wong Kim Ark case. And Lupton Singh, this was 1884, quite a few years before. And it was already important to the Chinese community to have birthright citizenship. The community realized children born here with citizenship have more rights and were more protected. So at the same time, we have the Chinese American Citizens Alliance formed in 1895. Same time this was happening. This was a group of American-born Chinese formed to start this civil rights organization, and they're still around. There's 18 branches of them throughout the US. And Luk Tin Singh, his adult name was Luk Tin Eli. And for those who's familiar with Chinese American history, after the earthquake, he was the person that organized the community to push back against the city, which wanted to move Chinatown to south of Hunters Point. And he organized all the Chinese and said, we built Chinatown back as a tourist attraction. Maybe the city will let the Chinese stay here. And this worked. Chinatown, where it is today, is because of Luk Tin Eli, the adult name of Luk Tin Singh. More interestingly for me, his mother was a Native American who was unable to be a citizen until 1924. So all these things happened at about the same time. Of course, the Wong Family Association, people with surname Wong supported Wong Kim Ark. They are the largest number of Chinese with that surname in San Francisco, so a powerful organization. And then the Chinese Consolidated Benevolent Association, better known as the Six Companies. These are the 6 counties where most of the Chinese came from in America, but each county spoke a different dialect, had different foodways, had different deities, so they were very different. But the community was able to get together, all 6 counties, and was really the city hall of Chinatown to raise the money to hire these 2 great lawyers to defend Wong Kim Ark. Wong Kim Ark was under 25, he was a cook, had no money, but the 6 company raised the money, and these 2 were great lawyers that usually you couldn't even hire. One was a former Attorney General of the U.S., was a Secretary of State of the U.S., and the other was the co-founder of the American Bar Association. So it took the 6 companies to raise the money to do this. And all these organizations are around. I'll stop here. If you want to know more, if you get 10 friends together, you can find me at the Chinese Historical Society of America. I'll give you a tour for the price of lunch. So just contact the Chinese Historical Society if you want to visit some of these places and learn about, the Chinese took about 30 cases to the Supreme Court during this short period, about 25 years after the Exclusion Act.
Thank you so much. It's an honor to be here with all of you and to follow what was really an extraordinary presentation. I am a professor of constitutional law at UC Berkeley, and I have been writing about a subject that winds up, now I've learned tonight, intersects in multiple ways with our topic. I have been writing about the World War II mass incarceration of Japanese Americans, and in particular a book about a woman who was detained with your mother at Topaz, named Mitsuye Endo Tsutsumi. Ms. Endo was the namesake of the habeas case that began here in the Northern District called Ex parte Endo, that went all the way to the Supreme Court. And what many people don't know is that she turned down release to stay in the camp at Topaz to keep her case alive. And what people also don't know is that her case directly led to the closing of those camps by forcing FDR finally to concede to agreeing to close the camps, which happened mere hours before the Supreme Court handed down a victorious decision in the case. In the process of researching that case, I learned that also here in the Northern District, an effort was made in spring of 1942 to strip all native-born Japanese Americans of their citizenship. This was on top of the orders that had been handed down by General DeWitt to require all persons of Japanese ancestry in the Western states, including, of course, California, to be subject to registration requirements, curfew requirements,
and eventually evacuation, as the government called it, removal is probably a better term, and then incarceration in 10 so-called relocation centers. In the midst of those orders being handed down, the Native Sons of the Golden West, through their secretary, John T. Regan, filed Regan versus King, a lawsuit in this court against San Francisco's voting registrar. The ostensible purpose was to strip the voting rights of all Japanese Americans, some 2,600 here in San Francisco. Interestingly enough, we've talked about the lawyers who were conscripted to help Wong Kim Ark, and it included one former attorney general. In the case of the Native Sons and Regan versus King, a former California Attorney General Ulysses Webb represented the Native Sons and made arguments very much at odds with those made in defense of Wong Kim Ark's citizenship. In particular, in the lawsuit, as it unfolded, Webb made clear that the entire purpose of the lawsuit was to get the decision in Wong Kim Ark overruled. He said that he hoped the lawsuit would provide an opportunity for the Supreme Court, quote, to correct itself. He gave many a speech here in the district court and at the Ninth Circuit, in which he claimed, among other things, that the United States had been settled by the white race, and that the Constitution's opening words, referencing "we the people," exclusively comprehended the white people. He then was very dismissive in discussing the Wong Kim Ark decision, describing the holding as resting on the idea that for no good reason, the United States was bound by the common law of England, which had somehow crept its way into American law. For any lawyers and law students in the room, you're raising an eyebrow because, of course, English common law is the basis of Anglo-American jurisprudence. The trial judge who presided over Regan versus King was also the trial judge who presided over the case, the prosecution of Fred Korematsu for failing to evacuate the Western areas and eventually report to camp. He would convict Fred Korematsu, but he very quickly dismissed Regan versus King, saying effectively, Wong Kim Ark has been decided, it is the law of the land, and it has been reaffirmed on multiple occasions. This is not a hard case, Judge St. Shore made clear to convey. Not to be discouraged, the Native Sons appealed to the Ninth Circuit, the appellate court. And here they said the quiet part out loud. In their brief, they argued because of racial characteristics of the Japanese, assimilation with Caucasians is as impossible as it is undesirable. They also made more inflammatory claims about Japanese Americans, and finally argued, echoing the phrase that General DeWitt had used in testimony before Congress, that a Japanese born in the United States is still a Japanese. The idea, of course, was the argument made in Wong Kim Ark that Japanese Americans were, even when born here, considered subjects of the Emperor of China and therefore had dual allegiance. The argument was, therefore, that they weren't completely subject to the jurisdiction of the United States. Notably, during World War II, Italian Americans born here, just like Japanese Americans born here, were also treated by their parents' home countries as citizens of those countries. But the Native Sons did not in any way seek to challenge the citizenship of Italian Americans born here. The Ninth Circuit arguments are really a resounding underscoring of how much Wong Kim Ark as a decision had become settled law. The Ninth Circuit judges heard the appeal in Regan versus King while sitting on day, all 7 of the judges present, on what the newspapers called Jack Day in court. The reason the newspaper said that is because Regan versus King was argued on the very same day as appeals in Hirabayashi, Yasui, and Korematsu, 3 of the 4 Japanese American decisions that made their way to the Supreme Court. In those 3 cases, unlike Ex parte Indo, the Japanese American litigants all lost, seeing convictions for violating registration, curfew, and evacuation orders upheld by the United States Supreme Court.
The Ninth Circuit judges themselves certified some of those cases, but also affirmed Ed Korematsu's conviction. So it was not a bench that was especially sympathetic to Japanese interests, Japanese American interests, or civil rights for that matter. Nonetheless, after Webb made his argument on behalf of the native sons of the Golden West that Wong Kim Ark should be overturned and that Japanese Americans born on American soil should not be considered to be American citizens, the 7 judges of the Ninth Circuit stopped the proceedings and after whispering with one another very briefly said, "It is not necessary to hear from the other side. The decision of the district court is affirmed." The deliverer of that message was Judge Curtis Wilbur, notably a former Secretary of the Navy and now judge on the Ninth Circuit. The case, again, was so easy to the judges, they didn't even need to hear an argument in defense of birthright citizenship. The native sons responded with 2 last-ditch efforts, both of which failed. First, they sought review in the Supreme Court. Without comment, the court denied review in the case. And they did so mere weeks before handing down the unanimous decision in United States versus Hirabayashi, in which the Supreme Court upheld a conviction for violating curfew and registration requirements, unanimous, and in language that was sweeping and not at all language that we would want to repeat today in terms of how they spoke Japanese Americans. Nonetheless, even in that context, the Supreme Court denied review and refused to revisit Wong Kim Ark. The native sons reacted with one final effort. They sought to propose an amendment to the United States Constitution and its 14th Amendment in particular that would read all persons born of citizens or naturalized in the United States and subjected to the jurisdiction thereof are citizens of the United States and of the states in which they reside. Of course, that would have excluded all persons born to individuals who were not allowed to naturalize, which was most Asian Americans and Asian immigrants at that time. Here too, the efforts of the native sons failed. I told this story in an amicus brief that I filed with the Supreme Court in the Barber case. I can only hope someone in some chambers read it. I also wrote a summary of the story for the Atlantic, where I played out some of the similarities between the arguments that were made by the native sons, and the Trump administration today. We all wait for that decision.
Thank you. Wanted to say just a closing word about the title that was given to this session, which is a discussion about American identity and legal legacy. And thinking about those pieces, I think it does summarize the many different stories that we've heard woven into the tapestry tonight. When we think about the legacy of Wong Kim Ark, we can think about this idea of birthright citizenship as one that is in the very founding of this nation and from the time of Dred Scott in the Civil War, the enactment of the 14th Amendment, onward to Chinese Americans like Wong Kim Ark himself in 1898. In World War II, as Professor Tyler related, during the Japanese internment, and then onward to Latino Americans, people who have come across the US-Mexico border later in the 1900s, back to the Chinese after the 2000s, concerns about temporary visa holders coming to the United States and having children as so-called tourists, and also the US territories that were mentioned in the script, in cases that have come before the court just in the last 8 or 9 years. So when we think about the ripple effects, they really are ripple effects, not just through time, but across communities. And I think that's important for us to remember. The last thing I would say is that when we think about what's at stake today, I think it's important to realize that the variety of people who are impacted are as wide in breadth as they are long in time. The concrete impact of the executive order that's being reviewed in Harvard would be about 260,000 undocumented immigrants or 33,000 temporary visitors a year. The children of those individuals could be impacted. The countries that they come from, yes, are China, but also Taiwan, South Korea, Russia, Brazil, Mexico, Nigeria, and Turkey. Some of the biggest impacts could be the creation of underclass for the children themselves or for their mixed class families. impacts on their own legal status, their right to stay in the United States, their right to be shielded from deportation, travel benefits like Social Security, Medicaid, SNAP, their rights to vote, to serve on juries. And of course, the many different chilling effects that are not affected by the actual laws, but the fears that are created by these proposed laws. So when we think about this legacy, it is definitely a broad and deep one. I would just close by saying that I think we need to remember that this case is not about immigration. This case is about being American. It's about American identity. I myself am the child of 2 temporary visa holders at the time that I was born here in the United States as a U.S. citizen. If we had not had Wong Kim Ark, I would not be a U.S. citizen. If we had not had Wong Kim Ark, Norman and Sandra would also not be U.S. citizens.
Thank you.
I want to thank you all for joining us for this program tonight, and thank our sitting judges, our high school students, our lawyers, and of course, our amazing panelists for everything they have provided tonight in terms of the perspective of what is at stake now in the Supreme Court and the legacy of the Wong Kim Ark case that was decided over a century ago. Thank you all for your attention. We have a reception here afterwards, and our panelists have agreed to stay to answer a few questions. So I hope you will seek them out. Thank you.